State of Cannabis.
This is the State of Cannabis News Digest, a roundup of this week's key developments in the cannabis industry.
Illinois and Delaware are tightening control of intoxicating hemp, while an Ohio court has temporarily reopened part of that market. Virginia is edging closer to licensed recreational sales, even as New Hampshire blocks an expansion of medical cultivation, and South Carolina's candidates reopen the debate over medical cannabis. For the industry, the pressure is increasingly financial. Los Angeles wants unlicensed dispensaries to pay cannabis taxes. Michigan is considering license caps as operators confront a steep wholesale levy. And in Washington, federal rescheduling may not deliver the tax relief businesses expected. The legal stakes are rising too. Louisiana is increasing penalties for marijuana use near schools, while the Supreme Court has limited when cannabis use alone can cost someone the right to own a firearm. We will bring you the details, the disputes, and what each development could mean for patients, consumers, and businesses. Stay with us for the full reports. This broadcast uses AI-generated voices to help make the show clearer, more varied, and more dynamic. The reporting, writing, and editorial decisions are guided by our news team. The voices allow us to present the program with greater range, pace, and personality. And if you are new to the show, subscribe on your preferred platform. If you already follow us, please hit the like button and help more listeners find the program.
And now here is the deeper look at the key events in the cannabis world this week.
Illinois has enacted a broad cannabis and hemp law that immediately prohibits sales of intoxicating hemp products to anyone younger than 21. Governor J.B. Pritzker signed Senate Bill 3222 on June 12th. The measure applies to products including Delta-8 THC, Delta-9 THC, THC-P, and HHC that have been sold outside Illinois' licensed adult-use cannabis system. Those products must now follow age restrictions similar to recreational marijuana. The law also requires child-resistant packaging and prohibits misleading designs that imitate familiar consumer brands or appear intended to attract children. A larger regulatory shift begins on November 12th. On that date, Illinois will replace its Industrial Hemp Act with a new Illinois Hemp Act. The framework will prohibit the sale, distribution, manufacturing, or production of hemp products without the required authorization or license. It also establishes penalties, product recalls, and enforcement under consumer fraud laws. The legislation reaches beyond intoxicating hemp. It doubles adult-use cannabis possession limits and increases the threshold for automatic expungement from 30 grams to 60 grams. Licensed dispensaries may offer drive-through service and curbside pickup, while craft growers receive additional cultivation capacity. The law also changes parts of the medical cannabis system involving patients, caregivers, identification cards, dispensing organizations, warning labels, confidentiality, and taxes. In Chicago, the statewide framework takes the place of a separate local approach after Mayor Brandon Johnson vetoed a city hemp ordinance in February. The next major date is November 12th, when the new licensing system begins.
Delaware lawmakers are considering a similar move towards stricter control of intoxicating hemp, although the proposal has not yet become law. The State House voted 35-4 on June 16th to approve House Bill 395. The legislation would generally classify a consumable product as marijuana when it contains more than 0.4 milligrams of total THC in the retail container. The definition would include Delta-8, Delta-9, Delta-10, and similar compounds, whether they occur naturally or are produced through synthetic or chemical processes. Products exceeding that threshold could be sold only through licensed marijuana businesses. They would then become subject to Delaware's testing, labeling, packaging, potency, and age control requirements. The proposal is aimed at products that have sometimes been sold outside the licensed cannabis market without the same consumer protections. It would not prohibit industrial hemp. Hemp containing no more than 0.3% total THC by dry weight would remain legal. Lawmakers say the bill is not intended to disrupt lawful hemp farmers or processors. The distinction depends on the finished product. A consumable may begin with legally cultivated hemp, but still fall under marijuana regulations because of the total THC contained in the final package. Unlicensed cultivation, storage, sale, distribution, or delivery of covered products would generally be a Class A misdemeanor. Certain circumstances, including operations near schools or involving minors, could result in a Class G felony charge. House Bill 395 is now before the Delaware Senate Health and Social Services Committee. It must advance through the committee and the full Senate before moving further in the legislative process.
While Illinois and Delaware are moving toward tighter regulation, a federal court has temporarily reopened part of Ohio's intoxicating hemp market. U.S. District Judge Jeffrey Helmick issued a 14-day restraining order allowing a group of hemp manufacturers to resume sales while they challenge Ohio Senate Bill 56. The order may be extended. Senate Bill 56 took effect in March and reclassified intoxicating hemp as cannabis. That generally restricted sales to licensed marijuana dispensaries and removed affected products from breweries, convenience stores, online sellers, and other businesses outside the regulated cannabis system. The manufacturers argue that Ohio's approach conflicts with the federal definition of hemp established by the 2018 Farm Bill. That federal standard focuses on a product's Delta-9 THC concentration. It has allowed some products containing Delta-8, Delta-10, and related cannabinoids to remain legally classified as hemp, even when they produce intoxicating effects. Judge Helmick found that the companies were likely to succeed on that claim. His ruling remains preliminary. It does not invalidate Senate Bill 56 across Ohio, and businesses outside the lawsuit remain subject to the state restrictions, unless they receive separate legal protection. Ohio officials say stricter rules are necessary because intoxicating hemp products have been sold without dispensary safeguards and, in some cases, have been available to minors. Hemp manufacturers and breweries argue that the state cannot simply redefine federally lawful hemp as marijuana. The dispute may eventually be overtaken by federal policy. New federal rules scheduled for November 12th are expected to rely on total THC content and could make most intoxicating hemp products illegal nationwide. For the businesses involved in the Ohio lawsuit, the immediate victory is temporary. The larger legal future remains uncertain.
Virginia may finally be approaching licensed recreational marijuana sales after years of political disagreement. Governor Abigail Spanberger and state lawmakers have reached a compromise that would open an adult-use retail market on July 1, 2027. The agreement follows an earlier legislative breakdown. The General Assembly passed a retail framework, but Spanberger returned it with dozens of amendments. Lawmakers rejected more than 40 of those changes, and the governor vetoed the legislation. Negotiations continued after the veto, producing a revised plan that is expected to be included in the state budget. The market would authorize 350 retail locations. Spanberger had proposed 200, but the compromise restores the larger number preferred by lawmakers. Licenses would be issued in phases, allowing regulators to monitor store locations and adjust the rollout. Adults could purchase up to 2 ounces in a single transaction. The state cannabis tax would begin at 6% and increase to 8% in 2029. Local governments could impose an additional tax ranging from 1% to 3.5%. The agreement also authorizes up to 100 microbusiness licenses by May 1, 2027. A cannabis impact business support team would assist businesses and communities affected by previous cannabis enforcement. Public consumption would remain prohibited and would carry a civil fine of $250. The governor had proposed treating it as a Class 4 misdemeanor, but the final compromise uses a civil penalty. The agreement is not yet final. It depends on approval of Virginia's budget package before July 1st. Until that occurs, the proposed 2027 opening date remains part of a negotiated plan rather than enacted law.
In Los Angeles, voters have approved a measure extending existing cannabis business taxes to unlicensed dispensaries and operators. Measure CB received 72% support in the city's June election. If the results are certified and the measure becomes operative, it is expected to take effect during the summer. The measure does not create a new tax schedule. Instead, it applies the city's existing cannabis rates to businesses operating without a license. General cannabis sales carry a 10% city tax. Medical cannabis sales are taxed at 5%, while cultivation is taxed at 2%. Los Angeles estimates the measure could produce between $30 million and $35 million in additional annual revenue. The central question is how the city will collect it. Officials have not explained how Los Angeles will identify unlicensed operators, examine their sales, or enforce tax obligations against businesses already operating outside the licensing system. The measure does not legalize those businesses. It addresses their tax liability, not their licensing status. The vote also comes as licensed operators face substantial financial difficulties. As of March, licensed cannabis businesses in Los Angeles collectively owed more than $400 million in back taxes and fees. The City Council asked the Office of Finance to prepare language for a possible amnesty program, although it is not clear whether that proposal has advanced. For consumers, the measure leaves another unanswered question: whether unlicensed businesses will pass the taxes on through higher prices or absorb the costs themselves. Voters have approved the obligation. The practical outcome will depend on collection and enforcement.
Michigan lawmakers are considering limits on cannabis business licenses as operators face a new wholesale tax and continued pressure on profits. The State Senate Regulatory Affairs Committee held a second hearing on Senate Bill 597 on June 17th. The latest version would limit marijuana retailer and wholesaler licenses to one for every 10,000 residents in each municipality. The proposal would also prevent growers, processors, and dispensary operators with unpaid state cannabis taxes from receiving or renewing licenses. Those businesses would have to pay the original tax debt along with applicable fees and penalties. The bill's sponsor, Senator Sam Singh, says the Cannabis Regulatory Agency currently cannot stop an operator from closing a licensed business with unpaid taxes and later applying for another license. The legislation also includes a moratorium on new grower licenses. Existing growers could still expand and receive an additional license. Another provision would require marijuana products to be returned within 3 days and in their original packaging and containers. The debate is taking place after Michigan adopted a 24% wholesale marijuana tax through its 2025-26 budget agreement. Lawmakers projected that the tax would generate about $420 million annually for roads. The cannabis industry is challenging the tax in court and argues that actual revenue will be lower. Singh says Senate Bill 597 was not written in response to those revenue concerns. Work on the licensing proposal began in April 2025. He has also acknowledged that the wholesale tax rate may be higher than it should have been. The committee took no further action after the hearing. For now, the license cap, grower moratorium, tax debt restrictions, and return requirement remain proposals.
Rhode Island has filled the top position on its Cannabis Control Commission. The state Senate unanimously confirmed Michelle Reddish as commission chair on the final day of the legislative session. Reddish has led Rhode Island's cannabis office since 2024. She now moves from an operational role into the commission's policymaking position. The independent agency oversees the state's medical marijuana, recreational cannabis, and hemp industries, including licensing and regulatory supervision. The chair is the commission's only full-time position and carries an annual salary of over $204,000. Reddish fills the vacancy created in October when former chair Kim Ahern resigned to run for Attorney General. Her term continues through May 17, 2031. The Senate also reappointed Commissioner Robert Jacquard to a second term ending on the same date. The confirmations do not immediately change cannabis access, possession rules, taxes, or purchasing requirements. They also do not produce an announced change in licensing or enforcement policy. For now, the significance is institutional. Rhode Island's cannabis regulator again has a permanent leader, and that leader already has 2 years of experience directing the state cannabis office.
Washington cannabis businesses may not receive the federal tax benefits they expected from medical marijuana rescheduling. The U.S. Department of Justice issued an April 23 rule moving state-licensed medical cannabis and products approved by the Food and Drug Administration from Schedule 1 to Schedule 3. Adult-use cannabis remained in Schedule 1. That distinction creates a problem for Washington because the state does not issue separate licenses for medical marijuana producers, processors, or retailers. Washington operates a unified recreational market. Businesses within that system may produce and sell Department of Health compliant products to registered patients and designated providers, but they do so under recreational licenses. The Washington Liquor and Cannabis Board says those businesses do not appear to qualify as state-licensed medical marijuana operators under the federal rule. If that interpretation remains in place, Washington companies may continue to be affected by Section 280E of the Federal Tax Code. Section 280E prevents businesses handling Schedule 1 or Schedule 2 substances from deducting ordinary business expenses on federal tax returns. It does not apply to Schedule 3 substances. The state agency says its memo is not a final legal determination. Washington businesses may still apply for registration with the Drug Enforcement Administration. Federal officials could determine that a recreationally licensed business qualifies when it actively serves medical patients, or they could reject that interpretation. The Internal Revenue Service and Treasury Department are preparing additional guidance. A broader DEA hearing on Schedule 3 treatment is scheduled to begin June 29th. For patients and consumers, current access remains unchanged. For businesses operating in Washington's billion-dollar cannabis market, the possibility of federal tax relief remains unresolved.
Medical marijuana has become an area of partial agreement in South Carolina's race for governor. During a Republican runoff debate, Lieutenant Governor Pamela Yvette and Attorney General Alan Wilson both said they were open to some form of medical cannabis legalization. Yvette said she would consider legislation if lawmakers drafted it narrowly and prevented it from becoming a path to recreational use. She referred to her father's death from lung cancer and said she would have welcomed a treatment that might have eased his pain during his final days. Wilson also opposes recreational legalization, but said medical applications deserve consideration under clearly defined rules. He pointed to veterans living with post-traumatic stress disorder, as well as patients with seizures, chronic illnesses, and terminal conditions. Democratic nominee Jermaine Johnson also supports legal medical marijuana. His campaign favors allowing voters to decide recreational legalization through a statewide referendum. The candidates' positions do not change South Carolina law. The state Senate passed medical cannabis proposals in 2022 and 2024, but both stalled in the House. Another version introduced for 2025 did not advance. Earlier legislation would have allowed qualifying patients to receive cannabis through therapeutic cannabis pharmacies licensed by the State Board of Pharmacy. A physician's recommendation would have been required. A separate legal argument concerns federal rescheduling. State Senator Tom Davis says moving medical cannabis from Schedule 1 to Schedule 3 may activate older South Carolina laws and create authority for medical use. The governor's office says the state must adopt a corresponding federal order while health officials continue to assess the implications. Medical cannabis now has support from candidates across party lines. Establishing a program, however, will still require legislative action or a clear legal effect from federal rescheduling.
New Hampshire Governor Kelly Ayotte has vetoed a bipartisan proposal that would have allowed medical marijuana dispensaries to operate greenhouses at their existing locations. Senate Bill 468, sponsored by Republican Senator Howard Pearl, would have limited each dispensary to one greenhouse. Supporters argued that additional cultivation could increase the medical cannabis supply and reduce prices for patients. Ayotte rejected the proposal, saying she does not support expanding marijuana cultivation in New Hampshire. The veto leaves the state's existing medical cannabis system unchanged. New Hampshire legalized medical marijuana in 2013. Qualified residents need a physician-issued card, and state law limits patients to 2 ounces. The market remains relatively small. 4 non-profit alternative treatment centers operate 7 dispensaries across the state. It is not clear how much additional cannabis the proposed greenhouses would have produced, or how much they might have affected prices. New Hampshire remains the only New England state that has not legalized recreational marijuana. Ayotte has repeatedly opposed adult use legalization, citing concerns about impaired driving, youth mental health, and quality of life. The vetoed bill, however, applied only to medical cultivation. The decision may not be final. The legislature is expected to consider an override later in 2026. Supporters would need 2/3 of both the House and Senate. The original vote totals do not establish whether that threshold is within reach.
Louisiana is strengthening penalties for certain marijuana and controlled substance offenses committed near schools and college campuses. Governor Jeff Landry signed House Bill 568 on May 22nd. The law takes effect August 1st. It applies to covered conduct on school property, within 2,000 feet of school grounds, and on school buses. Smoking marijuana in those locations was already illegal. The new law changes and clarifies the available punishment. Under the marijuana-related provision, a person convicted of smoking, vaping, or otherwise using a covered substance may face up to 1 year in jail and a fine of as much as $1,000. The broader drug-free zone provisions can impose the maximum fine authorized for an underlying offense and a prison sentence of as much as 1.5 times the usual maximum. Landry said marijuana smoke has become common at some high school and college campuses. The bill's author, Representative Gabe Ferment, said the measure is intended to change behavior at campus events and create an environment more suitable for families and children. Enforcement may be difficult. East Baton Rouge District Attorney Hiller Moore said an officer would generally need to witness a person smoking or vaping marijuana. He does not expect the law to produce a substantial increase in cases. Critics have raised concerns about unequal enforcement. Marijuana lobbyist Kevin Caldwell said poor and working-class residents and people of color could face a disproportionate share of prosecutions. He also questioned why alcohol use is not addressed in the same manner. The law does not change Louisiana's medical cannabis program, and the available information does not identify a specific exception for registered patients. Its practical effect will depend on how officers, prosecutors, and courts apply the revised penalties beginning August 1st.
The U.S. Supreme Court has unanimously limited the federal government's ability to disarm a person solely because that person regularly uses marijuana. The case involved Ali Daniel Hamani, a Texas man who told FBI agents that he used cannabis about every other day and owned a Glock pistol. Federal prosecutors charged him under a law prohibiting firearm possession by unlawful users of controlled substances and people with drug addiction. A conviction can carry a prison sentence of as much as 15 years. The government did not show that Hamani carried the firearm while intoxicated, misused it, or became dangerous because of marijuana. Writing for the court, Justice Neil Gorsuch said regular cannabis use alone was not sufficient to remove Hamani's Second Amendment rights. The Justice Department had argued that all regular marijuana users could be treated as dangerous. The court rejected that position as inconsistent with the historical tradition of firearm regulation. The justices compared the case with early American laws concerning habitual drunkards. Those laws focused on intoxication or incapacitation, rather than automatically disarming every person who regularly consumed alcohol. The ruling does not eliminate the federal statute. Firearm restrictions may still apply to people who are addicted, currently intoxicated, convicted of felonies, or individually shown to pose a danger. The decision also does not create a right to carry or handle a firearm while impaired. Instead, it limits the government's ability to impose an automatic firearm ban based only on regular marijuana use. The ruling arrives as federal cannabis policy is changing in other areas, including medical marijuana rescheduling and the Bureau of Alcohol, Tobacco, Firearms, and Explosives review of how it defines an unlawful drug user. For cannabis consumers, the decision narrows one federal conflict between marijuana use and firearm ownership. It does not resolve all of them.
Those are this week's major cannabis policy developments. This podcast is released every Saturday at 9 a.m. For new listeners, subscribe or follow the program on your preferred platform so the next episode appears automatically. For existing subscribers, please hit the like button, leave a rating or comment, and share the program with anyone following cannabis law, business, and policy across the United States. Thank you for listening.